Before we dive in, it's crucial to understand that this video is for informational purposes only and does not constitute legal advice. The laws can be complex and vary by state and individual situation. I am not an attorney. If you believe your rights have been violated, please consult with a qualified legal professional. Alex checks his work email one last time before bed. Just a quick 5-minute scan. He does it again over coffee the next morning. It's no big deal, right? He's a salaried employee, it's just part of the job. Except over a year, those quick scans added up to over 80 hours of unpaid work. That's 2 full work weeks. For free. What if I told you that for millions of Americans just like Alex, that isn't just part of the job? It's illegal wage theft. And it's just one of dozens of ways employees lose money, security, and peace of mind every single day, simply because they don't know the rules of the game. That's why we're here. This isn't a law class. This is your survival guide. Over the course of this presentation, we are going to arm you with the fundamental knowledge of your rights as an employee in the United States. We'll cut through the legal jargon and give you the plain English truth about what you're owed, how you must be treated, and what your boss absolutely cannot legally do to you. We're talking about your paycheck, your time off, your privacy, and your safety. By the time we're done, you'll be able to spot red flags from a mile away and have the confidence to protect yourself in the American workplace. This is the information that can save you thousands of dollars and prevent years of stress. So let's get into it. Let's start with the most fundamental right of all, the right to be paid for your work. This seems obvious, right? But the details are where companies save billions and workers lose out. The cornerstone of all this is a federal law called the Fair Labor Standards Act, or the FLSA. Think of it as the national rulebook for pay. It sets the floor for 2 massive concepts: minimum wage and overtime. First, minimum wage. The federal minimum wage is the absolute lowest hourly rate an employer can legally pay most workers. Now, you've probably heard that this number is ridiculously low, and it is. But here's the critical part. Many states and even cities have their own higher minimum wage laws. And the rule is simple. You are entitled to whichever rate is higher. If your state says the minimum is $15 an hour, it doesn't matter what the federal law says. Your employer must pay you $15. This is non-negotiable. Tipped employees are a bit more complicated, but the core principle remains. Your tips plus your base wage must at least equal the full minimum wage for all hours worked. If they don't, your employer has to make up the difference. Period. Now let's talk about the big one. The one that trips up everyone: overtime. The FLSA is crystal clear on this for most workers. If you work more than 40 hours in a single work week, you must be paid 1.5 times your regular rate of pay for every hour over 40. Not your regular pay, time and a half. So if you make $20 an hour, your overtime rate is $30 an hour. This is where companies get creative. And it all hinges on one little word: exempt. You've heard the terms exempt and non-exempt. They sound like corporate jargon, but understanding them is the difference between getting paid what you're owed and working for free. Non-exempt means you are not exempt from overtime laws. You get paid time and a half. Most hourly workers in America fall into this category: cashiers, construction workers, nurses, administrative assistants, call center reps. If you clock in and clock out, you are almost certainly non-exempt. Exempt means you are exempt from overtime. You're typically paid a flat salary, and whether you work 40 hours or 60 hours, your paycheck stays the same. But here's the secret your boss might not tell you. They can't just slap the exempt label on you because they feel like it. To be legally exempt, you must meet very specific criteria. It's not just about being paid a salary. You also have to perform certain types of job duties. These usually fall into categories like executive, administrative, or professional. Think of it this way. An executive exemption isn't for someone with a fancy title. It's for someone who genuinely manages the business, directs the work of at least 2 other employees, and has the power to hire or fire. An administrative exemption isn't for a secretary. It's for an office worker whose main job involves exercising independent judgment on significant matters related to business operations. Think an HR manager or a purchasing agent, not someone just following procedures. A professional exemption is for jobs requiring advanced knowledge, like doctors, lawyers, architects, or engineers. Why does this matter so much? Because one of the most common forms of wage theft is misclassifying employees. A company will hire a manager for their fast food restaurant, pay them a salary, and call them exempt. But if that manager spends 90% of their day working the cash register and mopping floors just like the hourly crew, and has no real authority to hire or fire, they likely aren't legally exempt. They're a non-exempt worker in disguise, and they are owed overtime for all those 50 or 60-hour weeks they've been working. This happens every single day in this country, but it gets even more granular. What actually counts as work? This is another goldmine for shady employers. The rule of thumb is, if you are required to be somewhere or do something for the benefit of your employer, you should be getting paid for it. This is called being suffered or permitted to work. It doesn't matter if your boss didn't explicitly ask you to do it. If they know you're doing it and they let you, they have to pay you. Remember Alex checking emails at home? That's work. What about the 15 minutes it takes to put on mandatory protective gear before your shift starts? That's work. What about the mandatory team meeting before the restaurant opens? That's work. Driving the company van from the shop to the first job site of the day? Often that's work. Even short rest breaks, typically 5 to 20 minutes, are generally considered paid time under federal law. Your employer can't force you to clock out for a 10-minute coffee break. They also can't just average your hours over 2 weeks. If you work 30 hours one week and 50 the next, they can't say, well, that's an average of 40, so no overtime. It doesn't work that way. Overtime is calculated on a single workweek basis. That 50-hour week requires 10 hours of overtime pay. And what happens when you leave your job? Whether you quit or get fired, you are entitled to your final paycheck. Federal law doesn't specify an exact timeline, but it says it must be on or before the next regular payday. However, many states have much stricter rules. In some states, if you're fired, they have to pay you immediately or within 24 hours. If you quit, they might have to pay you on your last day or on the next scheduled payday. They cannot withhold your final paycheck because you didn't return a company laptop or because they're mad at you. That money was earned by you. It is your property. They can potentially sue you for the cost of the unreturned equipment later, but they can't hold your wages hostage. This is the absolute foundation. Getting paid correctly, and getting paid on time. Minimum wage, overtime, and what counts as work. It seems simple, but millions of Americans are shortchanged on these basic principles every year. Because it's death by 1,000 cuts. A few minutes here, an hour there. A misclassification that seems legitimate on the surface. It all adds up to a massive transfer of wealth from your pocket to your employer's bottom line. But what about when your boss tries to get clever? What about offering you comp time, extra paid time off, instead of overtime pay? Or making you an independent contractor to avoid all these rules entirely? That's where the game gets more complex, and where knowing your rights becomes even more powerful. Let's start with that independent contractor label. It sounds empowering, doesn't it? You're your own boss. You set your own hours. You're a freelancer, a consultant, a gig worker. But here's the billion-dollar question the Department of Labor asks. Are you really in business for yourself? Or are you just an employee in disguise? Because if a company misclassifies you as an independent contractor when you're actually an employee, they dodge a massive list of responsibilities. They don't have to pay you overtime. They don't have to pay minimum wage. They don't have to pay their share of your Social Security and Medicare taxes. They don't have to cover you under unemployment insurance or workers' compensation. All of that financial burden, it gets shifted from their corporate shoulders directly onto yours. This isn't a small loophole. It's a canyon, and millions of workers fall into it every year. So how do you know the difference? The IRS and the Department of Labor don't care what your contract says, or if you signed a piece of paper that calls you a 1099 contractor. They care about the reality of the relationship. They use something called the economic reality test, which sounds complicated, but we can boil it down to a few common sense questions. First, how much control does the company have over you? Do they tell you when and where to work? Do they dictate the exact way you have to perform your job step by step? Do they require you to attend mandatory meetings or wear a uniform? If you have to ask for permission to take a day off, you're probably not your own boss. A true independent contractor controls the means and methods of their own work. They're hired to produce a result, not to follow a rigid process. Think about it like this. If you hire a plumber to fix a leak, you tell them which pipe is broken. You don't tell them which wrench to use or what time to take their lunch break. You're paying for their expertise and their result. That's a contractor. But if that plumber has to show up at your house every day at 8 a.m., wear a specific jumpsuit, use only tools you provide, and follow a 20-step manual for every task, that person is your employee, no matter what you call them. Second, who's making the real investment? A genuine contractor often has a significant investment in their own business. They buy their own tools, their own equipment, their own software. They have their own office or workshop. If the company provides you with everything you need to do the job, the computer, the vehicle, the supplies, the desk, that's a strong indicator you're an employee. Third, what's your opportunity for profit or loss? A contractor's profit isn't just their hourly rate. They can make more money by working more efficiently, by taking on multiple clients, or by managing their costs well. They also bear the risk of loss. If a project goes badly, they might lose money on it. If you're just getting paid a set hourly wage or a fixed rate per task, with no real ability to increase your profit through your own business acumen, you look a lot more like an employee. Let's put this into a real-world scenario. Meet David. He works for a delivery app. The company calls him a delivery partner, an independent contractor. He uses his own car, sure, but the app dictates every single part of his day. It tells him which orders to take, the exact route to drive, and how to interact with the customer. He has performance metrics he has to meet, or he risks being deactivated, which is just a fancy word for fired. He doesn't set his own prices. He can't build his own client base through the app. He has no real opportunity for profit beyond just working more and more hours. Is David really running his own delivery business? Or is he just a delivery driver for a company that has found a clever way to avoid paying for his gas, his car maintenance, his overtime, and his payroll taxes? The courts and the Department of Labor are increasingly saying it's the latter. They're looking past the gig economy buzzwords and seeing the economic reality. David is an employee. And if you're in a similar situation, you might be too, and you could be entitled to thousands of dollars in back pay and benefits. Now let's switch gears to that other tricky tactic, comp time. This one sounds so much more reasonable. You're a dedicated, non-exempt, hourly employee. You're staring down a huge deadline, so your boss asks you to stay late all week. You end up working 50 hours. That's 10 hours of overtime. Come Friday, your boss claps you on the back and says, "Incredible work this week. Instead of paying you that time and a half, why don't you just take 10 hours off next week on us? Go home early a couple of days." It all evens out. This is called compensatory time or comp time. And for almost every private sector employee in the United States, it is illegal. Let me say that again because it's a shock to a lot of people. Giving you paid time off in a future week instead of paying you cash for the overtime you worked in the current week is a violation of the Fair Labor Standards Act. Why? The law is designed for two reasons. First, it's about putting money in your pocket when you earn it. The whole point of a wage is that it's paid promptly for the work you performed. Your landlord doesn't accept comp time for your rent. The grocery store doesn't let you pay for food with a promise of a future day off. You work the hours, you are entitled to the pay for those hours in that pay period. The second reason is even more important. The time and a half overtime premium isn't just there to reward you. It's there to penalize the employer. It's designed to be a deterrent. The government wants to create a financial disincentive for companies to overwork their employees. By making those extra hours 50% more expensive, the law encourages employers to hire more people and spread the workload, rather than burning out their existing staff. When a company offers you comp time, they are completely sidestepping that penalty. They get all the benefit of you working 50 or 60 hours during a critical week, without any of the extra costs the law imposes. They get to bank your labor, and let you use it later when it's more convenient for them, not you. It turns the entire purpose of overtime pay on its head. Now, there is a major exception: government employees. Public sector agencies, like state or city governments, are often allowed to offer comp time under very specific rules, usually as part of a collective bargaining agreement. But if you work for a private company, a restaurant, a construction firm, a tech startup, a retail store, anything that isn't the government, that offer of comp time is almost certainly illegal. They must pay you 1.5 times your regular rate of pay in cash for every hour you work over 40 in a work week. This leads us to one of the most abused and misunderstood concepts in the American workplace: the idea of being salaried. So many companies believe that if they just take an hourly worker and put them on a fixed weekly salary, they suddenly don't have to pay overtime anymore. They think the word salary is a magic wand that waves away all the rules of the 40-hour workweek. They are dangerously wrong. Being paid a salary does not, by itself, make you exempt from overtime. It's only one part of a very specific 3-part test. You also have to be paid a certain minimum salary amount, and most importantly, your actual job duties must fall into a very narrowly defined category, like being a high-level executive, a creative professional, or an administrator with significant independent authority. Your job title doesn't matter. Your boss can call you the vice president of sandwich artistry. But if your actual job is making sandwiches on an assembly line, you are owed overtime. This is the salaried non-exempt trap, where companies pay you a flat salary to make your pay predictable, but then work you 50, 60, or even 70 hours a week, claiming you're not entitled to another dime. This single misunderstanding costs American workers billions of dollars a year in stolen wages. And figuring out if you're truly exempt or if you're a salaried employee who is still owed overtime, well, that's where the real power lies. So let's pull back the curtain on that power. It's hidden in plain sight, in a set of rules called the Fair Labor Standards Act, or the FLSA. And it all comes down to three little words: the duties test. Your employer can call you whatever they want. They can give you a fancy title like Director of First Impressions instead of Receptionist, or Lead Sanitation Engineer instead of Janitor. They can put you on a salary and tell you that means you're a professional. But your title means absolutely nothing to the Department of Labor. Your salary structure means almost nothing. What matters, the only thing that truly matters, is what you actually do day in and day out. To be legally exempt from overtime, you generally have to meet two conditions. First, you have to be paid a salary above a certain threshold, which as of late 2023 is just over $35,000 a year. But that's the easy part. The second condition, the one where millions of employees are misclassified, is that your primary job duties must fit into one of a few specific categories. The most common ones are the executive, administrative, and professional exemptions. And this is where we need to pay very close attention. Let's start with the executive exemption. This is the manager loophole. Think about Sarah. She's the assistant manager at a national coffee chain. She's on a salary of $40,000 a year. She works 50, sometimes 60 hours a week, especially during the holidays. She never sees a dime of overtime because she's told she's management. But what does Sarah actually do? She spends about an hour a week making the schedule. The rest of her time, she's on the floor taking orders, steaming milk, cleaning the espresso machine, and dealing with customer complaints, working right alongside the hourly employees. The law says that to be an exempt executive, your primary duty must be managing the enterprise. You must customarily and regularly direct the work of at least two other full-time employees. And here's the kicker. You must have the authority to hire or fire other employees, or your suggestions and recommendations as to the hiring, firing, advancement, or promotion of other employees must be given particular weight. Sarah's primary duty isn't managing. It's making coffee. Her main job is the same as the baristas she supposedly manages. She can't hire or fire anyone. That's all done by the district manager. She can tell a barista to go clean the bathroom, but that's not the kind of high-level supervision the law is talking about. Sarah's misclassified. That title, assistant manager, is a sticker they slapped on her to avoid paying her for the 100+ hours of overtime she works every single month. She is a victim of wage theft, plain and simple. Next, let's look at the administrative exemption. This is one of the most misunderstood and abused exemptions in the entire country. The legal test says your primary duty must be the performance of office or non-manual work, directly related to the management or general business operations of the employer or the employer's customers. And your primary duty must include the exercise of discretion and independent judgment with respect to matters of significance. That sounds complicated, so let's talk about Mike. Mike works for a logistics company. His title is Logistics Coordinator, and he makes $45,000 a year salary. He works from 8 a.m. to 6 p.m. every day, tracking shipments in a computer system. His job is to follow a very specific 20-step procedure when a shipment is delayed. He checks box A, enters data into field B, and sends a pre-written email from template C. He's told he's exempt because his work is administrative and keeps the business running. But let's break that down. Is Mike's work related to the general business operations? Yes, kind of. But does he exercise discretion and independent judgment on matters of significance? Absolutely not. Mike isn't deciding which shipping company to partner with. He's not negotiating fuel contracts. He's not developing new logistics strategies. He is following a strict set of rules. His job is production, not administration. He is producing a result, an updated shipment status, by following a manual. He is a production employee who happens to work in an office. The company could hire 10 more Mikes, and they would simply produce 10 times the amount of updated shipment statuses. That's not high-level administrative work. Mike is being denied overtime illegally. He's being paid for 40 hours but is giving his company 50 hours of his labor for free every single week. The difference is this. An exempt administrative employee affects the policies or the overall operations of the business. A non-exempt employee is the one doing the day-to-day work, the production of the company's product or service. So ask yourself, are you creating the playbook? Or are you just running the plays exactly as they were drawn up? If you're just running the plays, you are almost certainly owed overtime. Finally, there's the professional exemption. This one is split into two types, learned and creative. The learned professional is what you typically think of: doctors, lawyers, dentists, teachers, accountants. Their work requires advanced knowledge in a field of science or learning, usually acquired through prolonged, specialized instruction. This one is pretty straightforward. But the creative professional exemption is another swamp of misclassification. This applies to jobs where the primary duty is the performance of work requiring invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. Think musicians, composers, writers, some journalists, actors. But here's the trap. Let's imagine Jessica, a graphic designer, at a large marketing firm. She's salaried at $50,000. She's told she's a creative professional, and therefore exempt from overtime. But what does Jessica do all day? She takes existing templates, drops in new photos provided by the client, changes the name and the date on the copy, and exports it in 5 different sizes. She might get to choose between 2 pre-approved fonts. She's not inventing a new brand identity from scratch. She's not exercising significant artistic originality. She's performing skilled but routine work. Many journalists who are just rewriting press releases, or graphic artists who are just making minor modifications to existing layouts, are misclassified as creative professionals, when their jobs don't actually involve that high level of invention or originality the law requires. They are essentially digital assembly line workers, and they are owed overtime for every minute they work past 40 hours. So forget your title. Forget that you're paid a salary. Look at what you actually do. Are you truly managing the business? Or just making the coffee? Are you shaping company policy? Or just following a flowchart? Are you creating original works of art? Or just coloring by numbers in a corporate template? Answering these questions honestly is the first step to uncovering potentially thousands of dollars in wages that you have earned, and that you are owed. Because your time is valuable. And the actual law says your employer has to pay you for it. But knowing you're owed overtime is only half the battle. Because what actually counts as work? What about the 10 minutes you spend booting up your computer before your shift? Or the 15 minutes you're required to be at your station before the doors open? Does that time count? The answer is a lot more complex than you think. And it's another area where employers quietly skim millions of dollars from their employees' pockets every single year. Let's start with a simple, almost universal workplace scenario. Imagine you work at a popular retail store. Your official shift starts at 9 a.m., the moment the doors open to the public. But your manager has a rule. Everyone must be on the floor, ready to go, for a mandatory team huddle at 8:45 a.m. You talk about sales goals, new promotions, and who's covering which section. It's only 15 minutes. After your shift ends at 5 p.m., you spend another 10 to 15 minutes closing out your register, tidying your area, and waiting for a manager to check your work before you can clock out. So you're at the workplace for an extra 25 to 30 minutes every single day. Is that your time, or the company's time? The vast majority of employees in this situation are told, either directly or implicitly, that this time is unpaid. It's just part of the job. It's the cost of being a team player. You're not technically working with customers, so it doesn't count. This is one of the most pervasive and damaging lies in the American workplace. And it is, in almost every case, illegal. The foundational law here is the Fair Labor Standards Act, or FLSA. The FLSA has a very powerful and intentionally broad definition of what constitutes work. It says an employer must pay you for all hours you are suffered or permitted to work. Let's break that phrase down because it's the key to everything. Permitted to work is obvious. If your boss tells you to do something, you're permitted and you must be paid. But suffered to work is the game changer. This means that even if your employer doesn't explicitly ask you to do something, if they know you are doing it, and they don't stop you, they have suffered you to work and they have to pay you for that time. If your manager sees you tidying up your station after you've clocked out and just lets you do it, that is legally work time. If they know you have to come in early to get your computer system booted up and logged into 5 different programs before you can actually start taking calls at 9 a.m., that is time they are suffering you to work. And they owe you money for it. The Department of Labor is crystal clear on this. Work is not just the time you spend on your main task. It includes all the time you spend performing activities that are an integral and indispensable part of your principal activities. That pre-shift meeting at the retail store? It's about the job, directed by the manager, and for the benefit of the employer. It is absolutely integral and indispensable. Therefore, it is paid time. Period. The moment that meeting starts at 8:45 a.m. is the moment your paid workday begins. The time spent putting on required specialized safety gear, like in a factory or on a construction site, is work time. The time a call center employee spends booting up their computer and launching necessary software is work time. The time a nurse spends at the end of a shift completing patient charts is work time. Now, employers have a favorite little trick they use to get around this. They'll often cite something called the de minimis rule. The de minimis rule basically says that for trivial, insignificant amounts of time that are difficult to track, an employer might not have to pay. They'll tell you that those 10 or 15 minutes are de minimis, and therefore don't count. This is a deliberate misinterpretation of the law. The de minimis rule was intended for things like the 10 seconds it takes you to read a quick email from your boss after you've clocked out, or the 30 seconds you spend answering a colleague's question on your way to the door. It was not intended to cover a regular, predictable 15-minute block of time that occurs every single day. If your employer requires you to be somewhere or do something work-related for 15 minutes before your shift, that is not de minimis. It is a quarter of an hour of your life, dedicated to their business, and they are legally required to pay you for it. Let's do some quick math, because this is where the scale of this theft becomes shockingly clear. Let's say you're an hourly worker making a modest $15 an hour. And let's say you're required to do 15 minutes of unpaid work before your shift and 15 minutes after. That's 30 minutes a day. Doesn't sound like much, but 30 minutes a day, 5 days a week, is 2.5 hours of unpaid labor every week. 2.5 hours at $15 an hour is $37.50. That's your gas money for the week. That's your lunch budget. That's a copay for a doctor's visit. But it gets worse. Over a 50-week work year, that 2.5 hours per week adds up to 125 hours of unpaid work. 125 hours times $15 an hour is $1,875. Let that sink in. By convincing you that it's just a few minutes, your employer could be stealing nearly $2,000 from you every single year. Now multiply that by every employee in the company. We are talking about millions upon millions of dollars in stolen wages, siphoned directly from the pockets of the lowest paid workers. This issue has gone all the way to the Supreme Court. There have been massive class action lawsuits against some of the biggest companies in the world for this exact practice. A famous case involved Amazon warehouse workers who were required to wait in long security screening lines after their shifts ended to ensure they weren't stealing anything. They argued correctly that this time, sometimes up to 25 minutes, was for the sole benefit of the employer and was outside of their control. They were forced to be there. While the Supreme Court ultimately ruled against those specific workers in a complex decision, it sparked a huge public conversation and led many states to pass their own, stronger laws protecting employees in these situations. For example, in states like California, the law is much more explicit. If you are under your employer's control, you are on the clock. Waiting in a mandatory security line is being under your employer's control. So what's the takeaway for you? First, understand the suffered or permitted standard. It is your most powerful tool. Second, be deeply skeptical of the de minimis excuse. If it's a regular, daily activity that takes more than a minute or two, it is almost certainly not de minimis. Third, document everything. Keep a private log of the time you actually arrive, the time you start your pre-shift duties, the time you end your post-shift duties, and the time you are finally allowed to leave. Your own records are powerful evidence. This isn't about being greedy or a troublemaker. This is about being paid for your time. Your time is the most valuable, non-renewable resource you have. You trade it to your employer for a wage. When they take your time without paying for it, it isn't just unfair. It's theft. Pure and simple. They are stealing your life minute by minute. So the rule is this: if you are required to be at a specific place, and you are not free to use that time for your own purposes, you are working. And if you are working, you must be paid. This applies to pre-shift meetings, post-shift cleaning, booting up computers, putting on uniforms or gear at the workplace, and waiting in mandatory security lines. Now, this naturally brings up a very tricky question. If your employer has to pay you for all the time you're under their control, what about the breaks they give you during the day? What about your 30-minute lunch break? Can your boss ask you a quick question while you're eating your sandwich? Can they ask you to cover the front desk for just 5 minutes while someone else runs to the bathroom? Does that mean your entire lunch break should have been paid? The laws around meal and rest breaks are one of the most shocking and widely misunderstood areas of employment law, and what you don't know about them could be costing you even more. Let's get right into it. The federal law, the Fair Labor Standards Act, or FLSA, does not, and I want you to hear this clearly, it does not require employers to provide any meal or rest breaks at all. I'll say it again. There is no federal law in the United States that says your boss has to give you a lunch break. Shocking, right? Millions of Americans assume this is a fundamental right, but at the federal level, it simply isn't. An employer could legally require you to work 8 straight hours with no break whatsoever. But here is the multi-million-dollar catch. While federal law doesn't force them to give you a break, it is incredibly strict about how they handle breaks if they choose to offer them. And this is where companies get into a world of trouble. Let's start with short breaks. Think of your 10 or 15-minute coffee break. The Department of Labor is crystal clear on this. Any rest period of 20 minutes or less is considered part of the workday and must be paid. It is non-negotiable. If your boss tells you to clock out for your 15-minute break, they are breaking the law and committing wage theft. It doesn't matter if they call it a smoke break, a coffee run, or just a chance to stretch your legs. If it's short, it's on the clock. This time is given to promote efficiency and benefits the employer, so they have to pay for it. The moment you clock out for that 15-minute break, you are donating your labor and your money directly to your company's bottom line. Now let's talk about the big one, the meal break. This is what the law calls a bona fide meal period. Typically, this is 30 minutes or longer, and employers are generally not required to pay you for this time. But, and this is one of the most important buts in all of employment law, it is only unpaid under one single critical condition. You must be completely and totally relieved of all duties. Not mostly relieved, not kind of relieved, 100% completely, utterly free. You must be free to leave the premises, go for a walk, run an errand, sit in your car and listen to a podcast, or do whatever you want. The time must be yours. Let me paint you a picture. Let's call our employee Jessica. Jessica works the front desk at a busy logistics company. She gets a 30-minute unpaid lunch break every day. She clocks out and goes to the break room with her salad. 5 minutes in, her supervisor pops his head in. "Hey Jessica, sorry to bother you, but can you just cover the front desk for 2 minutes while Linda runs to the restroom? I'm swamped." Jessica, wanting to be a team player, says sure. She goes back to the desk, answers a phone call, and directs a delivery driver. Takes 5 minutes. She goes back to her now lukewarm salad. 10 minutes later, a coworker asks her a question about a client file. She spends 2 minutes pulling it up on her computer. Before she knows it, her 30 minutes are up, and she has to clock back in. Here is the bombshell. Because Jessica was not completely relieved of her duties, her entire 30-minute lunch break must be paid. Not just the 5 minutes she spent at the desk, not just the 2 minutes she helped her coworker. The whole thing. The moment her break was interrupted for a work-related task, it ceased to be a bona fide meal period under the law and became compensable work time. Think about that. How many unpaid lunches have you had where you answered a quick email, took a work call, or helped a customer? Each one of those interruptions may have legally converted your entire unpaid break into paid time that you are owed. This completely relieved of duty standard is incredibly strict. If your employer requires you to eat at your desk to answer the phone, your lunch must be paid. If you're a security guard who has to remain on site and watch monitors during your meal, your lunch must be paid. If you're a nurse who has to keep your pager on and be ready to respond to a code, your lunch must be paid. If you are not free, you are not on a break. You are on the clock. Now, while the federal law sets this floor, this is an area where state laws often provide much greater protection. This is crucial because your state might actually mandate breaks where federal law doesn't. For example, in California, employers must provide a 30-minute meal break if you work more than 5 hours a day, plus a paid 10-minute rest break for every 4 hours worked. In New York, workers are entitled to specific meal periods depending on their shift length and industry. Many other states like Colorado, Illinois, and Washington have their own specific rules. It is absolutely essential that you do a quick search for your state meal and rest break laws to see the specific protections you have. But let's talk about one of the most sinister ways this right is violated: the automatic meal break deduction. Many large companies, especially in retail, food service, and manufacturing, use payroll software that automatically deducts 30 or 60 minutes from an employee's daily time card for a lunch break. The system just assumes you took it. But what happens on those days when you're slammed? When the store is short-staffed, the production line is behind, or there's a deadline and your manager says, "Sorry, no time for a full lunch today, just grab a bite when you can." You work right through that break. But the computer doesn't know that. It still deducts the 30 minutes from your paycheck. This isn't a hypothetical. This is a massive, widespread form of wage theft that affects millions of workers. Let's say you're forced to work through your 30-minute auto-deducted lunch just twice a week. That's 1 hour of unpaid labor every week. At $15 an hour, that's over $750 a year stolen right out of your pocket. And companies know this. They rely on the fact that employees won't check their pay stubs, won't question the system, or are too afraid to speak up. It is your employer's legal responsibility to ensure you are paid for all time worked, and that includes breaks you were told to skip. An automatic deduction policy is only legal if the company also has a clear and effective way for employees to report when they didn't get their break, and ensures they are paid for that time. So, your boss can't interrupt your unpaid lunch without paying you for the whole thing, and they can't use an automatic system to avoid paying you for the breaks you never got to take. But this control over your time raises a much bigger question. What about the time after you've officially clocked out for the day? What about that quick email your salaried manager asks you to answer at 9 p.m.? Or that urgent group text about a work problem on a Saturday morning? You might think that's just part of the modern workplace, but the line between being a salaried professional and an hourly worker is one of the most abused and misunderstood concepts in American labor law. And a simple misunderstanding here could mean your employer owes you thousands, or even tens of thousands, in unpaid overtime. So how does this happen? How do you end up with a secret unpaid paycheck worth tens of thousands of dollars? It all starts with one of the biggest lies in the American workplace: the myth of the salary. Your boss sits you down, offers you a job with a nice round salary number, say $55,000 a year. Sounds professional, sounds official, and you're told, because you're on salary, you're not eligible for overtime. You're expected to work until the job is done, whether that's 40 hours a week or 80. And for millions of Americans, that's the end of the story. They accept it as fact. But in many, many cases, it is legally false. The law that governs this is called the Fair Labor Standards Act, or the FLSA. The FLSA says that most employees must be paid overtime, time and a half, for any hours worked over 40 in a work week. These employees are called non-exempt. Think of it this way: they are not exempt from overtime pay. But the law carves out exceptions for certain types of employees. These employees are called exempt. They are exempt from overtime pay. And this is where the games begin. An employer can save an astronomical amount of money by incorrectly classifying a worker as exempt. They get all the extra hours of your labor for free. To be legally considered exempt from overtime, an employee has to pass a series of very specific tests. It's not about your job title. It's not about whether you're paid a salary. It's not about what your boss decides to call you. You can be called the Supreme Vice President of Global Strategy, but if your actual job duties don't meet these tests, the law says you are owed overtime. There are 3 main tests, and you have to pass all 3 to be considered exempt. First is the salary basis test. This one is simple. You must be paid a predetermined, fixed salary that doesn't change based on the quantity or quality of your work. If your boss docks your salary because you left 2 hours early for a doctor's appointment one day, you likely fail this test. Your salary is supposed to be a guaranteed amount for any week in which you do any work. Second is the salary level test. Your salary has to meet a certain minimum threshold set by federal or state law. The federal minimum under the FLSA changes, so you'll always want to check the current number with the Department of Labor. As of late 2023, that number was $684 per week, which is about $35,568 per year. If you are paid a salary less than this federal minimum, the analysis stops right there. You are non-exempt. You are owed overtime. Period. And remember, your state might have an even higher salary threshold. In California or New York, for example, the minimum salary to even begin to qualify as exempt is significantly higher. But here's the third test. This is the one where the vast majority of misclassification happens. It's called the duties test. and it's all about what you actually do day to day. There are several categories of duties that can make you exempt, but we're going to focus on the 3 most common and most commonly abused: the executive, administrative, and professional exemptions. Let's start with the executive exemption. To qualify, your primary duty must be managing the enterprise or a department. You must regularly direct the work of at least 2 or more full-time employees. And here's the kicker: you must have the authority to hire or fire other employees, or your suggestions and recommendations on hiring, firing, advancement, or promotion must be given particular weight. Think about the assistant manager at a retail store or a fast food chain. Let's call her Sarah. Sarah is paid a salary of $45,000 a year. She works 55 hours a week. She unlocks the store, she makes schedules, and she makes sure the shelves are stocked. She's called a manager, so she's exempt, right? Wrong. Let's look closer. Is her primary duty management? Well, she spends about 75% of her time doing the exact same work as the hourly employees. Running the cash register, stocking shelves, and cleaning the floors. Does she direct the work of 2 or more employees? Yes, she does. But can she hire or fire anyone? No. All of that is handled by the district manager. Does her recommendation carry particular weight? Not really. The DM makes the final call on everything. Sarah is a classic example of a misclassified employee. Her title is manager, but her duties are those of a non-exempt, hourly worker. She is likely owed thousands of dollars in back overtime pay. Next, we have the most confusing and abused category of all: the administrative exemption. This is a minefield of misunderstanding. To qualify, your primary duty must be the performance of office or non-manual work, directly related to the management or general business operations of the employer or the employer's customers. And this is the most important part. Your primary duty must include the exercise of discretion and independent judgment with respect to matters of significance. Let's break that down. Discretion and independent judgment doesn't mean just being good at your job or deciding when to order more printer paper. It means you have the authority to make significant decisions without immediate direction or supervision. It means comparing and evaluating possible courses of action and making a decision after the various possibilities have been considered. Are you formulating company policies? Are you handling major financial assignments? Are you involved in business planning? Let's look at an example. An office manager named David is paid a salary of $60,000. His duties include greeting visitors, sorting mail, ordering office supplies from an approved list, and scheduling meetings for his boss. He's reliable and does his job well. But is he exercising discretion and independent judgment on matters of significance? No. He's applying existing skills and following established procedures. He isn't shaping business policy or making major operational decisions. David, despite his title and salary, is almost certainly a non-exempt employee who should be getting paid time and a half for every hour he works over 40. Compare him to an HR manager who investigates complex employee complaints, develops new company-wide leave policies, and has the authority to settle disputes. That HR manager is likely exercising the required level of judgment and would be properly classified as exempt. The difference is not the title, it's the substance and significance of the work itself. Finally, there's the learned professional exemption. This one is a bit more straightforward. To qualify, your primary duty must be work requiring advanced knowledge in a field of science or learning, customarily acquired by a prolonged course of specialized intellectual instruction. Think doctors, lawyers, dentists, architects, engineers, and certified public accountants. The key here is advanced knowledge and prolonged course of study. It's not about having a general college degree. It's about a specific advanced degree that is a standard prerequisite for entering that profession. A paralegal, for example, is a highly skilled and vital role, but because it doesn't typically require the advanced law degree that a lawyer has, a paralegal is usually non-exempt and eligible for overtime. So let's go back to our retail assistant manager, Sarah. We already established she doesn't meet the executive exemption. Does she meet the administrative one? Is her primary duty related to business operations? And does she exercise independent judgment on matters of significance? No. Her primary duty is customer service and manual labor, stocking shelves. Her decisions are about which employee covers a lunch break, not about the store's marketing strategy or budget. She fails the administrative test, and she's obviously not a learned professional. Sarah has passed the salary basis and salary level tests, but she fails the duties test. And because she fails even one of the 3 tests, she is by law a non-exempt employee. Now for the part that matters most, the money. Let's do the math. Sarah makes $45,000 a year. Divide that by 52 weeks and you get about $865 a week. Divide that by a standard 40-hour work week, and her regular rate of pay is about $21.63 per hour. She works 55 hours a week, which is 15 hours of overtime. Under the FLSA, those 15 hours must be paid at time and a half. So, her overtime rate is $21.63 times 1.5, which equals $32.45 per hour. For those 15 hours of overtime, she should have been paid an extra $486.75 every single week. That's over $2,000 a month. That's over $25,000 a year that her employer kept by simply giving her a misleading job title. And the law generally allows you to go back 2, sometimes even 3 years to claim unpaid wages. For Sarah, this isn't just a mistake. It's a life-changing amount of money she earned and is legally owed. So I want you to stop and think right now. Not about your job title. Not about whether you get a salary. Think about what you actually do every day. Do you manage people with real authority to hire and fire? Do you have the power to make significant business decisions on your own? Are you a licensed professional with an advanced degree? If the answer to all of those is no, you need to take a much closer look at your pay stubs. Because your job title might say manager, but the law might say you're owed a fortune. But knowing you're owed the money is one thing. Actually getting it is a completely different battle. How do you approach your employer? What proof do you need? And most importantly, how do you do it without getting fired? Because as we're about to see, the moment you stand up for your rights, you gain powerful legal protections against retaliation. This is the single most important concept to understand because it's your shield. Retaliation is when your employer punishes you for doing something you are legally allowed to do. That something is called a protected activity. And a protected activity isn't just any complaint. You can't complain that the coffee in the break room is bad and be legally protected. A protected activity is when you assert a right guaranteed by law. Think about it. Complaining about wage theft? That's a protected activity under the Fair Labor Standards Act. Reporting unsafe working conditions? Protected activity under OSHA. Reporting sexual harassment? Protected activity under Title VII of the Civil Rights Act. The law recognizes that if people could be fired simply for pointing out that the law is being broken, no one would ever speak up. The entire system of rights would collapse. So, anti-retaliation provisions were built in as the system's backbone. The moment you engage in a protected activity, you are draped in a legal suit of armor. Firing you, demoting you, or punishing you after that becomes incredibly risky for your employer. So, how do you do it? How do you put on the armor? Let's walk through the playbook. Step 1, and this is the absolute, non-negotiable golden rule. Document everything. And I mean everything. Before you even think about opening your mouth, you become a meticulous record keeper. Get a notebook you keep at home, or start a document on your personal computer. Never ever on your work computer. Your work computer is company property. They can and will access it. Your personal notes are your private property. In this log, you will write down every single incident that feels wrong. Don't just write, "Mike was a jerk today." Be a journalist reporting on your own life. Write the date, the time, and the location. Who was present? Who saw it? What was said verbatim as best you can remember. Quote them. What was your response? How did it make you feel? If it's a wage issue, you're not just saving your pay stubs. You're tracking your actual hours worked in your private log. You're noting every time you were asked to work off the clock, every lunch break you had to work through. You are building a fortress of facts brick by brick. Why? Because memory is fickle, but a contemporaneous written record is powerful evidence. A complaint with a detailed, dated log is 100 times more credible than one based on vague recollections. Step 2. Clarify your objective. What is the outcome you want? Do you want to be paid the overtime you're owed? Do you want the harassment to stop? Do you want a safety hazard fixed? Knowing your specific goal prevents the conversation from becoming a general, emotional venting session. You want to present a problem and a potential solution, not just a list of grievances. This frames you as a proactive problem solver, not a complainer. Okay, you've got your documentation. You know your objective. Now for the most nerve-wracking part. Step 3, the approach. Your first move should almost always be internal, and it should be as professional and non-confrontational as possible. You are not walking in and accusing anyone. You are raising a concern. You are asking a question. Let's say you believe you're being misclassified as an exempt employee and aren't getting overtime you've earned. You schedule a meeting with your manager or an HR representative. You don't walk in and say, "You're breaking the law and stealing my wages." Instead, you say something calm and collaborative. "Hi, thanks for meeting with me. I've been doing some reading to better understand my role, and I had a question about how my pay is structured. Based on my understanding of the Fair Labor Standards Act, my duties seem to align with non-exempt status. I was hoping we could review my job description and classification together to make sure everything is correct. It's possible I'm just misunderstanding something. Do you see the difference? You've stated the issue, cited the relevant law, but you've framed it as a mutual quest for clarification. You've given them the benefit of the doubt. This approach does two things. First, it gives the company a chance to fix the mistake gracefully. Maybe it was a genuine error. Second, and more importantly, it makes any subsequent punishment look incredibly suspicious. You were calm, you were professional, you were collaborative. If they suddenly fire you after that meeting, how can they possibly argue it was because you were disruptive or not a team player? You have the moral high ground, which brings us to step 4, the paper trail. After any verbal conversation, you follow up with an email. This is crucial. Send it from your work email to your manager or HR, and blind copy your personal email address so you have a copy. The email is simple. "Hi, manager's name. Just wanted to follow up on our conversation this morning, and thank you for your time. To make sure I understood correctly, we discussed my overtime classification under the FLSA, and you were going to look into it and get back to me. Please let me know if I've misstated anything. Thanks again." Boom. You now have a time-stamped, undeniable record that you engaged in a protected activity. You reported a potential violation of federal wage and hour law. The clock is now ticking. Any negative action they take against you from this moment forward will be viewed through the lens of potential retaliation. And retaliation is a much broader concept than just getting fired. It can be subtle, insidious. It's any materially adverse action that would be likely to dissuade a reasonable employee from making or supporting a similar charge. That's the legal standard. So what does that include? Could be a demotion. Could be cutting your hours. It could be reassigning you to a less desirable role or shift. It could be excluding you from meetings and projects you were previously a part of. It could be a sudden negative performance review after years of positive feedback. It could be hyper-scrutinizing your work, micromanaging your every move, looking for any tiny mistake to write you up for. It's a pattern of behavior designed to punish you and make your life at work miserable, pushing you to quit. This is where your documentation becomes your sword and shield. You complained on Monday. On Wednesday, you're suddenly put on a performance improvement plan for issues that have never been raised before. That's called temporal proximity. The closeness in time between your protected activity and the adverse action is powerful circumstantial evidence of retaliation. The company has to prove they took this action for a legitimate, non-retaliatory reason. But if you've been a good employee for years and suddenly days after you ask about your legal rights, you're labeled a problem employee, that story is very, very difficult for a company to sell to a jury or a government investigator. You're building a case. You're creating a timeline. Your professional, documented complaint, followed by their sudden negative action. You are connecting the dots for anyone who will look at this later. You're showing that their action wasn't a coincidence. It was a consequence. And remember, there is immense power in numbers. If you know a coworker is experiencing the same issue, you can approach the company together. This is called concerted activity, and it's specifically protected by the National Labor Relations Act, even if you're not in a union. Complaining as a group about wages or working conditions makes it much harder for an employer to retaliate. They can't fire the entire department. By acting together, you create a much larger shield. But what happens when the internal approach fails? When HR sides with the company and the retaliation gets worse? What do you do when you've built your fortress of facts, sent the professional email, and they still come after you? That's when you stop talking to them and start talking to the federal government. And the process for doing that is more straightforward than you think. The main federal agency you'll be dealing with for issues of discrimination, harassment, and retaliation is the Equal Employment Opportunity Commission, or the EEOC. Write those letters down. EEOC. Think of them as the federal government's HR department for the entire country. They are the enforcers of the major anti-discrimination laws we've talked about, like Title VII of the Civil Rights Act, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. When your employer crosses a line and then retaliates against you for speaking up, they aren't just fighting you anymore. They are potentially breaking federal law. And the EEOC is the agency that investigates that. Your first official step is to file what's called a charge of discrimination. This is a formal statement you submit to the EEOC, claiming that your employer has discriminated against you. This is not a lawsuit. I repeat, this is not a lawsuit. It's the mandatory first step you have to take before you can even think about suing for discrimination in federal court. It's the government's way of saying, let us look into this first. Filing this charge is what officially puts your employer on notice. It shifts the entire power dynamic. Before, it was just you against a company. Now it's you, with the United States federal government looking over the company's shoulder. And that is a very different ballgame. So how do you do it? The most important thing you need to know is the deadline. This is non-negotiable. You absolutely must file your charge with the EEOC within 180 calendar days from the day the discrimination took place. That's about 6 months. In some states, that deadline is extended to 300 days if there's a state or local law that also prohibits the same type of discrimination. But don't play games with this. Always assume you only have 180 days. Think about that. 6 months. A manager makes a discriminatory comment in January. You spend February and March trying to handle it internally. They retaliate in April. You spend May trying to figure out what to do, feeling stressed and overwhelmed. Suddenly it's June, and your deadline is staring you right in the face. Time is not your friend here. The moment you believe you are a victim of illegal discrimination or retaliation, the clock starts ticking. Okay, so you're within the deadline. What's next? You have a few ways to file. You can do it by mail, in person at an EEOC office, or the most common and easiest way, through the EEOC's online public portal. Let's walk through what you'll need. This is where all that documentation we talked about becomes your superpower. Remember that fortress of facts you built? This is the battle where you deploy it. You'll need the basics: your name and contact information, and the name, address, and approximate number of employees for the company you're filing against. Then comes the heart of the matter. You need to provide a short, clear description of the actions you believe were discriminatory. This is your story. When did it happen? What was said or done? Who was involved? You need to be specific with dates. Don't say sometime last spring. Say on or around April 15, 2023. You will need to state why you believe you were discriminated against. Was it because of your race, your gender, your religion, your disability, your age? You have to connect the bad action to your protected status. For example, I was terminated on May 1, 2023. My manager, John Smith, told me it was due to budget cuts. However, I was the only employee over the age of 50 in my department to be let go, and I was replaced a week later by a 23-year-old. In the months leading up to my termination, Mr. Smith made several comments about needing new blood and getting some younger energy on the team. See how that works? Facts, dates, a direct link to a protected characteristic, in this case age. If you are claiming retaliation, you need to describe that too. On April 10th, I sent an email to HR complaining about Mr. Smith's age-related comments. On April 12th, I was placed on a surprise performance improvement plan for the first time in my 15-year career with the company. On May 1st, I was terminated. The timeline tells the story. Cause and effect. Complaint and punishment. You'll upload your evidence to the portal. Those emails you saved? Upload them. The notes from conversations with dates and times? Upload them. That glowing performance review from 6 months ago, right before the new manager started? Upload it. This isn't the time to be shy. You are building a case. Once you submit your charge, the EEOC will review it and within about 10 days send a notice to your employer. Can you imagine the scene? Your boss or someone in HR opens an official-looking envelope. The letterhead says, U.S. Equal Employment Opportunity Commission. It informs them that a formal charge of discrimination has been filed against them and that they are now under a federal investigation. The casual dismissal, the threats, the retaliation, it all stops being an internal matter they can sweep under the rug. It is now a federal case file. They are legally required to respond. They are legally prohibited from destroying any documents related to your charge. And most importantly, they are absolutely unequivocally forbidden from retaliating against you for filing. If they do, that creates a second separate and often easier to prove charge of retaliation. After notifying your employer, the EEOC will typically take one of two paths. The first is mediation. The EEOC offers a free voluntary program where a neutral mediator helps you and your employer try to reach a settlement. This can be a good option if you want a faster resolution. You might negotiate a severance package, a job reinstatement, or other terms. If you both agree, the case is closed. If you can't agree, or if either party refuses mediation, the case moves to the second path. The second path is an investigation. An EEOC investigator is assigned to your case. This person does not work for you, and they do not work for your company. They work for the U.S. government. Their job is to be a neutral fact finder. They will interview you. They will interview witnesses. They will demand documents from your employer, emails, payroll records, personnel files, company policies. They have the power to gather the information that you, as an individual, could never get on your own. The investigation can take a long time, often many months, sometimes over a year. The agency is notoriously understaffed and overworked. But while it's happening, you have a shield. Your employer knows they are being watched. This entire process, filing the charge, triggering the investigation, costs you nothing. $0. It's a service provided by the federal government, funded by taxpayers, to enforce civil rights laws. It is one of the most powerful tools an individual employee has when facing an abusive or discriminatory employer. It levels the playing field like nothing else. So the investigator gathers all the facts. They interview everyone. They read all the emails. They look at the company's history. And after all that, they have to make a decision. They have to decide if there is reasonable cause to believe that discrimination occurred. And what happens then? What happens if the EEOC, after a full investigation, looks at all the evidence and says, yes, we believe you. We believe the law was broken? Conversely, what happens if they look at everything and say, we don't have enough evidence to make a finding? Either way, the outcome of that investigation leads to the EEOC issuing you one of the most important documents you will ever receive in this entire process. It's a single piece of paper, but it holds the key to everything that comes next. It's called a Notice of Right to Sue. And understanding what that letter means and what it allows you to do is the final step in taking the fight directly to your employer's doorstep. This notice is your golden ticket. It's the government officially saying, we've looked into it and now we're stepping aside. The arena is yours. Without this letter for federal discrimination claims, you simply cannot walk into a courthouse and sue your employer. The judge will throw your case out before you can even say objection. It is the non-negotiable prerequisite, the gatekeeper to justice. But this golden ticket comes with a ticking time bomb attached. And this is, without a doubt, one of the most critical and unforgiving deadlines in all of American law. Once you receive that notice of right to sue, a clock starts. You have exactly 90 days to file a lawsuit in federal court. Let me say that again because careers and cases have been lost by misunderstanding this. 90 calendar days, not 3 months, not 90 business days. 90 days from the date you are presumed to have received the letter. If your letter arrives on a Monday, day 1 is Tuesday. If day 90 falls on a Sunday or a federal holiday, you typically get until the next business day, but you do not want to be cutting it that close. This 90-day window is a guillotine. If you miss it by one day, one single day, your federal claim is gone. Forever. It doesn't matter how strong your case is. It doesn't matter how much evidence you have. It doesn't matter how badly you were wronged. The courthouse doors slam shut, and they do not reopen. The legal system is filled with sad stories of people who had slam dunk cases but waited until day 91. Their fight was over before it even began. So, how do you get this crucial letter? Usually, the EEOC will issue it automatically after they finish their investigation, regardless of the outcome. If they find no violation, they'll send it. If they find a violation but can't reach a settlement with your employer, a process called conciliation, they will also send it. But there's another way, a strategic option you need to know about. You can request your notice of right to sue from the EEOC. If 180 days have passed since you first filed your charge and the EEOC still hasn't made a decision, you have the right to say, okay, that's enough. Give me my letter. I'm ready to sue. This is a massive strategic decision. On one hand, if the EEOC is dragging its feet and you feel your case is strong, requesting the letter lets you take control and move forward. You can get the ball rolling with your own attorney. On the other hand, the moment you request that letter, the EEOC investigation typically stops. You're giving up on the chance that the government might find in your favor and fight on your behalf. You are willingly starting that 90-day time bomb. This is a conversation you absolutely must have with an experienced employment lawyer before you make a move. They can help you weigh the pros and cons based on the specifics of your case and the workload of your local EEOC office. Now that you have this letter in your hand and you understand the terrifyingly short deadline, the next question is obvious. What do I do now? The answer is you find a warrior to fight for you. You find an employment lawyer. And please hear me on this. Not just any lawyer. You would not go to a foot doctor for brain surgery. Do not go to your cousin who handles real estate closings for a complex employment discrimination case. This is a highly specialized field of law. You need someone who lives and breathes this stuff. Someone who knows the local judges, who knows the lawyers on the other side, and who knows the intricate dance of employment litigation. So where do you find this specialist? Start with the National Employment Lawyers Association, or NALA. It's an organization of lawyers who exclusively represent employees. Their website has a Find a Lawyer feature that is an incredible resource. You can also check your state and local bar associations, which often have lawyer referral services, and you can specify that you need an expert in employment law. Once you have a list of names, start making calls. You're looking for a consultation. Many employment lawyers offer free initial consultations. This is your interview process. You are hiring someone for one of the biggest fights of your life. Go prepared. Gather all your documents, your journal of notes, emails, performance reviews, your copy of the EEOC charge, and now your notice of right to sue. In that meeting, tell your story honestly and clearly. Don't embellish or hide the bad facts. A good lawyer needs to know the weaknesses of your case just as much as the strengths. Ask them tough questions. How many cases like mine have you handled? What is your trial experience? What are the potential outcomes? Who will I be dealing with primarily at your firm, you or a junior associate? And then you must discuss the most practical question of all. How do you get paid? Most people think they can't afford a top-tier lawyer. This is where you learn about the single most important financial arrangement in employee-side law: the contingency fee. A contingency fee means the lawyer only gets paid if you win. They take a percentage of whatever money you recover, whether through a settlement or a court verdict. That percentage can range, often from 33 to 40%, sometimes on a sliding scale depending on how far the case goes. If you lose your case, you owe them nothing in attorney's fees. Think about what that means. It means you don't need a massive bank account to take on a massive corporation. It means the lawyer has skin in the game. They are investing their time, their resources, and their firm's money into your case. They are betting on you. It perfectly aligns their financial interests with yours. They win when you win. This arrangement is the great equalizer. It gives a single employee the power to stand up to a billion-dollar company. Once you've found the right lawyer and signed an agreement, they will take that right to sue letter and begin drafting the single most important document in the entire process: the complaint. The complaint is the official document that starts your lawsuit. It's filed with the court and it lays out in formal legal language who you are, who your employer is, the facts of what happened to you, the specific laws you believe were violated, and what you are asking the court to do about it, whether it's financial damages, getting your job back, or other remedies. This document is your story, translated into the language of power. It's the first time you are no longer just an employee complaining to HR. You are now the plaintiff. Your employer is now the defendant. After the complaint is filed with the court, the next step is called service of process. This is where a copy of the lawsuit is formally delivered to your employer. Sometimes it's a private process server, sometimes it's a U.S. Marshal. Imagine the scene. A uniformed officer or a professional-looking stranger walks into your old corporate headquarters, past the smiling receptionist, and into an executive's office to hand them a stack of papers with your name on the front. This is the moment the fight becomes undeniable. It's no longer a private dispute. It is now a public record. The company is officially on notice that you are not going away. They have been sued, and now, under the full authority of the United States judicial system, they are legally required to respond. The power dynamic, which has been stacked against you since day one, has just been turned on its head. You've taken your pain, your evidence, and your resolve, and you've forged it into a legal weapon. You've filed the lawsuit. The first shot has been fired across the bow. But this isn't the end of the war. It's just the end of the beginning. What comes next is a grueling strategic battle of information, psychology, and nerve. It's a phase where cases are won and lost long before a jury is ever called. It's called discovery. and it's where your fight for justice truly gets real. Discovery isn't just a legal procedure. It's a war of attrition. It's the phase where your former employer, with their deep pockets and team of lawyers, tries to exhaust you into submission. Their goal is simple: to make the process so expensive, so emotionally draining, and so psychologically grueling that you either give up or accept a ridiculously low settlement offer just to make it stop. They are counting on you to break. But here's the secret they don't want you to know. Discovery is also where you get to turn the tables. It's your one state-sanctioned opportunity to kick down their corporate doors, open their filing cabinets, and read their private emails. It's where you find the proof they've been trying to bury. The battle is fought with 4 primary weapons. The first one they'll use against you is called interrogatories. Think of these as written landmines. Their lawyers will send your lawyer a long list of questions, sometimes dozens, even hundreds, that you must answer in writing under oath. These questions are not friendly. They are meticulously crafted to trap you. They'll ask things like, identify every single person you spoke to about your alleged harassment, the exact date and time of each conversation, and a summary of what was said. Or, provide a detailed list of every job you've applied for since your termination, including the company name, the date of application, the position, and the outcome. They want to overwhelm you. They're looking for inconsistencies. If your answer here is slightly different from what you later say in person, they will use it to paint you as a liar in front of a judge or jury. Answering these is a painstaking process you and your lawyer will spend hours on, making sure every word is precise and defensible. Feels like an attack, and that's exactly what it is. But then you get to fire back with your own weapon: the request for production of documents. This is where the power dynamic starts to shift. This is your legal warrant to search their house. Your lawyer will send them a list of every document you want to see. And we're not just talking about your employee file. We're talking about everything. Emails between your boss and HR about you, Slack messages, text messages on company phones, the personnel files of the person who replaced you or the person who harassed you, internal investigation reports, company financial records. All of those secret conversations you knew were happening behind your back? You now have the right to demand them. This is where the smoking gun is almost always found. Companies know this, and they will fight you every step of the way. They'll claim the documents are privileged, or irrelevant, or unduly burdensome to find. Their lawyers will object and delay, hoping you'll run out of money to pay your lawyer to fight them. But a good lawyer will hold their feet to the fire, filing motions with the court to compel them to produce what they're hiding. I've seen cases completely transformed by a single email. An email from a manager to HR saying, "We need to find a way to manage him out. He's getting too old for this team." Or a text message from one executive to another saying, "Just fire her. I don't care what the reason is, I'm tired of her complaints." Suddenly, your case isn't just your word against theirs. It's their own words in black and white proving your case for you. That is the power of a request for production. The third weapon is more subtle but just as deadly. It's called a request for admission. These are simple, direct, yes or no questions that you send to the company, and they are legally required to admit or deny them. Your lawyer will draft statements like, "Admit that you did not provide the plaintiff with mandatory overtime pay for the hours worked over 40. Or, admit that my client's performance reviews were satisfactory or better prior to her reporting sexual harassment." They can't waffle. They can't give a long-winded explanation. They have to admit it or deny it. The goal here is to narrow down the issues for trial. By forcing them to admit certain facts, you don't have to waste time and money proving them later. Every admit you get from them is another brick in the wall of your case, a fact that is no longer in dispute. And all of this leads to the main event, the most feared, most dramatic, and most important part of discovery: the deposition. A deposition is your sworn testimony, given out of court but under oath. You will be in a conference room. On one side of the table sits you and your lawyer. On the other side sits the company's lawyer, or maybe a whole team of them. There will also be a court reporter, typing down every single word you say, every sigh, every hesitation. This is the company's chance to question you face to face, for hours on end, sometimes for days. Their lawyer's job is to destroy your credibility. They will come at you from every angle. They might start by being friendly, trying to lull you into a false sense of security, hoping you'll start rambling and say something you shouldn't. Then they'll turn on a dime. They'll ask you the same question 5 different ways, trying to catch you in a contradiction. They'll twist your words. They'll ask you intensely personal, irrelevant questions about your past to see if they can embarrass you or make you angry. They want to see how you'll perform under pressure. They want to know if you'll break down and cry, or get furious and start yelling. They are testing you to see what kind of a witness you will be in front of a jury. Your lawyer's job is to protect you. They will object to improper questions, but for the most part, they will tell you to just answer the questions truthfully and calmly. The best advice for a deposition is simple, but incredibly hard to follow. Listen carefully to the question. Pause. Think about the answer. And then answer only the question that was asked. Nothing more. Don't volunteer information. Don't explain your answer unless you're asked to. If you don't know the answer, say, "I don't know." If you don't remember, say, "I don't remember." It is a brutal, exhausting, and intimidating experience designed to make you feel like a criminal on trial. But then it's your turn again. Your lawyer gets to depose their witnesses. Your boss, the head of HR, the coworker who retaliated against you. Now they are the ones in the hot seat. Now they are the ones who have to answer for their actions, under oath, with every word being recorded. It's in these depositions that stories unravel. Managers contradict each other. HR representatives admit to shoddy investigations. The entire corporate narrative, so carefully constructed, can fall apart under the pressure of a skilled lawyer's questioning. The discovery process can take months, sometimes more than a year. It's a slow, grinding war of paperwork, motions, and psychological endurance. The company is betting you don't have the stomach for it. But if you and your lawyer navigate it successfully, everything changes. You emerge from the fog of war not just with a story but with evidence. You have their emails. You have their admissions. You have their sworn testimony, full of contradictions and damning statements. The entire balance of power has shifted. Before discovery, you were an ex-employee with a grievance. After discovery, you are a plaintiff armed with proof. And that proof creates a level of risk the company never wanted to have. Now, they have a very serious calculation to make. Do they risk putting all of this evidence in front of a jury of your peers? Or do they finally come to the table and try to make this go away? The answer to that question will determine the next, and often final chapter of your fight.